New Zealand First supports this legislation.
I call Claire Curran.
Thank you, Mr Chair. I'd like to also echo what's being said tonight around this bill, about it being an important piece of legislation which is ultimately about trying to provide more of a fair go for consumers, and you'd think that in this Parliament that would be a priority, would be put on legislation that gets passed as quickly as possible, especially when it comes back from the Select Committee, when there's been such a lot of work done at the Select Committee on this piece of legislation, where there were a number of substantial changes made that were agreed to by the committee in consultation with the officials. I'd like to acknowledge the work done by officials on this. Pretty much all of the work that's being done in the consumer area it has got a lot of solidity behind it. And there is a lot of thought that's gone into it. It's not perfect, obviously, and we've had criticisms, particularly when it comes to the payday lenders and the loan sharks, etc. But with regards to this particular piece of legislation, there was a lot of good work that went into it, and it should have come back to this House well before it did, and it should have got through and become law well before it did. So basically, I'm echoing everybody on this side of the House on that particular issue tonight. Before I get into the substantive area that I want to cover tonight, I'd just like to say that one of the substantial changes that was made at the Select Committee was around the penalties. Was around penalties that are being imposed on breaches of the Fair Trading Act. And I just want to mention those breaches because they are quite substantial, and they went from 60,000 to 200,000 for individuals and 200,000 to 600,000 for bodies corporate. Now, you know, that might sound, those 60,000 may sound like a lot of money, but actually in order to prevent those breaches of the Fair Trading Act, that the increase in those penalties was important, and I think is a substantial part of this bill. Mr Chair, I'd also like to turn to one of the pieces of work in this that's been mentioned a couple of times tonight that still is yet to be dealt with in the legislation, and that's because we're waiting until Australia has developed a body of authoritative case law on the matter, and that matter is, and it's very pertinent on a number of issues, but very pertinent, particularly at the moment, is around this concept of unconscionable conduct. And treating this area very seriously, Mr Chair, that the unconscionability applies where the courts consider it unfair or inequitable or against good conscience to allow a party to enforce its contractual rights against another party who is detrimentally affected by an oppressive bargain. Well, there are many examples that could be used of this right now, but one of the most pertinent examples is in the area of chorus and the government. And I think the question that has to be asked is an inept contract an oppressive bargain? And I think that's a pretty pertinent question right now, because it appears pretty much as if there is some sort of issue. Somebody's to blame here, and there's so many questions that, and this issue seems to be changing day to day. But I certainly think that underpinning this is this concept of unconscionable conduct, and it's a pity. I put to you tonight in the House that this issue wasn't included in the bill, because then we might have actually had the ability for a remedy to try and, from another piece of legislation, to try and address this debacle that has occurred right now. Because is it chorus that's the problem, or is it the government? And who's telling the truth? Or is it both? And if it's both, then where's the unconscionable conduct? Is it the way that the contract was developed, or is it the way that the contract is being carried out? Or is it the fact that 2.5 years ago, when the legislation was written by the previous Minister, Stephen Joyce, who pushed through this legislation, which included a provision that everybody else in the industry seemed to know about, that was going to be reviewing, Mr Chair.
Clear, Karen.
Thanks, Mr Chair. And speaking to the unconscionable conduct aspect of this piece of legislation, everybody else seemed to know about this review that was going to happen of the copper pricing, except for the government, because Chorus knew about it because it was in their prospectus, their first prospectus that was put out. In fact, it was actually also in the regulatory impact statement.
Order. We're not talking about
It was in the regulatory impact statement, Mr Chair, of that piece of legislation, and it certainly has got relevance to unconscionable conduct, because the question that has to be asked is whether what has gone wrong? What has gone wrong with this contract? What has gone wrong between the government and the contracting company? And who knew what and who knew what when? And whether Chorus was going to go broke. And I put to you, Mr Chair, this is an extremely important issue that in this piece of legislation would be addressed potentially. Whether Chorus is going to go broke or whether they aren't going to go broke, because Chorus said they're not going to go broke, but the Prime Minister said they could possibly go broke. Whether the government was planning to legislate to override the Commerce Commission, or whether they weren't planning to legislate, despite the fact that the Minister has actually put out a review document that had 3 options in it.
This is not
Each
a
of those
debate
3
about
options included legislation.
Point of order, the Honourable Clayton Cosgrave.
Mr Chairman, I understand your point. However, it is within a member's right to use an example to illustrate a point within the legislation. And prior to you taking the chair, a number of members have used examples.
I hear the member, and using examples is fine, but this is not a debate on Chorus, and the member must come back to the substantive matter of the bill. Clear, Curran. Honourable Clayton Cosgrave.
Mr Chair, I think the point that was, if you just bear with me, I think the point that was being made is if you look at the piece of the legislation that's being referred to, there are 2 parties to a transaction, yep. and you can illustrate the point around that, and Chorus is extremely germane.
I thank the member, and I've made the ruling, is that the member must refer back to the substantive matter of the bill. That's what this is a bill about. It's not about a 5-minute talk or a speech on Chorus. Clear, Curran.
Thank you, Mr Chair. In the commentary to the bill on page 14, the unconscionable conduct part of the bill, it says that the Australian consumer law includes unconscionable conduct protections, but that those protections have encountered some technical problems. And the committee agreed that it was prudent to wait until Australia had developed a body of authoritative case law, as I started off my speech tonight, authoritative case law on the matter before following suit. Now, that was because that the committee considered that implementing unconscionability provisions could lead to a period of uncertainty while the provisions were tested by the courts in Australia and New Zealand. And I put to you tonight that there is a period of uncertainty happening right now that affects consumers in this country about whether their internet prices are going to stay up high or whether they're going to drop, which is what the Commerce Commission has recommended that they do, and actually put out a final decision that they do. Now, that is a fair trading issue, that is a consumer issue, and there is a period of uncertainty now. There are now 2 judicial reviews happening. One judicial review is on the Minister's own review, in which she had 3 options, each of which required legislation. The other judicial review is Chorus taking the Commerce Commission's final decision to court. Now, if that's not a period of uncertainty that is affecting consumers, I don't know what is. And there is unconscionable conduct that has occurred, and the question is, where has that unconscionable conduct occurred? Who is to blame? Who knew what when, and why is it that the consumers of New Zealand are going to end up paying? Because if Chorus is going to have to be bailed out by this government, then it's the consumers who are going to have to bail them out ultimately. And that is the essence, and that is why in this piece of legislation, which is all about consumer law reform, that there is this disconnect that seems to be occurring, where you've got a piece of legislation that sits on the order book for 2 years, doesn't go through the House, and you have a government that's basically coming up with one idea after another to try and bail out a private company and its shareholders to protect the dividends of that company. That is unfair. It's an unjust situation, and it's the consumers of New Zealand who are losing out.
Members, we come to the vote on the Honourable Clayton Cosgrove.
Mr Chair, I just want to take a brief call again on the theme that a number of us have spoken about excuse me, this evening, of unconscionable conduct. And within the commentary, as I referred to before, it talks about unconscionable conduct applying is considered as unfair or unequitable or against good conscience to allow a party to enforce its contractual rights against another party who is detrimentally affected by an oppressive bargain. Now, in case the Chair may think that I'm wandering away from the bill, the phrase I want to concentrate on directly for a moment are the words oppressive bargain. And I'm going to illustrate the point by another government decision, which two parties to which, sir, and you may have been distracted, sir, I'm referring directly to the words in here, oppressive bargain. And I'm going to illustrate that with an example. And the example is one of Rio Tinto. Two parties to a transaction, a contractual arrangement, yet one party negligently, stupidly negotiated a deal, paid a lot of money, gave away a number of components and got nothing back for it. Now, the question I'd have for the Minister, because she's a lawyer and she'll know far better than me, is would that be considered enforceable, given that Rio Tinto, not through any nefarious means but simply through good management, good negotiation and smarts, worked out that the government had nailed itself to a time frame to sell Meridian, therefore they waited until that timeline was almost going to be breached, and they sprung the trap. And the deal, sir, as I'm sure you and others will know, was that there was going to be job protection and all sorts of other things, benefits to Southland New Zealand. We're going to reign from the